Okay, so today we're going to be looking at alternative dispute resolution. This is the way that people handle civil cases when they are not looking to go the route of court. Now, there are several different reasons why a person would want to use alternative dispute resolution. This could be due to the fact that it is slow, hence my picture of a tortoise. The reason it's slow is because of all the processes that you have to go through with court, and that makes the process slow and lag. And when you want to just get some money out of someone for them causing you a misdemeanor, then you do not want to have to wait months and months for this thing to go through. Also, another reason why alternative dispute resolution is used is because it is very expensive to go through the courts because of lawyers and court costs. And if you turn out to lose, then you could have lost so much more money than if you just left the case in the first place. Another form of reason why dispute resolution is used is because the courts are quite strict and they have lots of procedures which you have to stick to, which not many people enjoy going through, and they'd rather do it themselves or use other means to do it. Okay, so we're going to look at negotiation, which is a first form of alternative dispute resolution. Most people negotiate on a daily basis, but when you're negotiating over civil cases, people tend to not focus on the issue as much as they're looking at what this person did and why they don't like this person. Without lawyers, they tend to focus more on that than the actual point of law. But lawyers are expensive, so that's why negotiation is used as opposed to the courts. You can negotiate right up to the last minute of a case. You could make a offer to someone if you know you're going to lose before the judge has made his or her judgment. And negotiation can be used for all types of disputes, any type at all, really. It doesn't really matter what the civil dispute is as long as it's civil. Okay, so next what we're going to look at is mediation. This is another form of alternative dispute resolution and is often used for people who want to be kept separate, cannot stand to be in the same room. The person who sort of acts as the go-between for the two parties is called the mediator. Now, the reason they're called this is because they will go between the two parties and tell the other party one of the party's suggested terms, and then they will go back to the other party and tell them what the other party thought. Now, they are completely impartial, so they can't get involved in the case. But it is a more private route if you don't want your civil case flashed all over the newspapers. Again, they're kept separate, so this is a good thing for people who cannot stand to even be in the same room. And it reduces the costs because you only have to pay for the mediator, so both sides don't need to pay for a lawyer or pay court costs. The results of mediation are legally binding. Once you have come to a decision, then you must stick to that, otherwise you will be breaking the law. Because of the Family Law Act 1996, couples who want to get a divorce normally go through mediation first to come to some terms of agreement. And West Kent Mediation Services are a good example of a company who will provide mediation. So that's a good little example to use in an exam question because they are always looking for examples. Now, the next form of alternative dispute resolution is almost like a sort of a step up from mediation. It's the next level. It's called conciliation. This is where you have a conciliator, much like a mediator, go between the two parties and create a sort of mode of communication for the two. Now, the conciliator organises dates and times that you'll be talking to each other. That'll be why there's a lady standing on a clock there, and where you will meet. That's, of course, is again why there's a little "you are here" sign. Now, the process is exactly the same as mediation, so you're going between the two parties, but there's more intervention from the conciliator. They can suggest terms of agreement for both parties so that both parties get the best deal out of it. And this is often used with employment disputes because employers can afford lots of lawyers because they are the ones with the money, whereas the employee, they're not going to be able to afford a lawyer. Okay, so next we have the final form of dispute resolution, and that is arbitration. Arbitration is like the most complicated of the alternative dispute resolutions, I'd say. The process is quite similar to a court in the way that both sides put forward their argument, and the arbitrator, much like a judge, will come to a decision over who he thinks deserves the award. People can include a Scott and Avery clause, which shows that if the two parties become fractioned or have a dispute, then they must go to arbitration before they try to go to court. And if they do try to go to court with the Scott and Avery clause in the contract, then the court will simply reject them until they have had arbitration. Now, the arbitrator is, like I said, a judge, but he is independent, and obviously he's not on the side of anyone. Arbitrators normally are enrolled from the Chartered Institute of Arbitrators and are an expert in the field that they're talking about. So if there's a dispute over agriculture, then they will be an expert in the field of agriculture and law in agriculture. Is there a right to appeal? That is the question, I hear you ask. Well, I answer you. Well, there's no automatic right to appeal, but you can appeal if there has been an error in a point of law. That's under Section 69 of the Arbitration Act 1996. That's a nice little one to drop in there in an exam. Examiners will love it. And if there has been a serious irregularity, that's under Section 68 of the Arbitration Act 1996. So, this has been a video on alternative dispute resolution. The four types are negotiation, mediation, conciliation, and arbitration. The next video I create will be advantages and disadvantages of each of the services, and then we will be talking about the civil courts and appeal structure. Thank you very much for listening. I hope this has helped you.